He has two cases.
Thank you.
State versus Harris.
We are on record in the Meigs Common Pleas Court in State versus Harris. Cases number 20. I'm sorry, it would be 18 CR 211 and 19 CR 220. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand, ma'am. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay. If you would please state your name.
Lula F. Harris.
And your address was provided on a piece of paper along with your email and phone number. Is that correct? That information that was provided accurate?
Yes, ma'am.
Right. And for the record, your attorney
Yes, good morning, Your Honor. I'm Denise Funds. I'm here on behalf of Miss Harris.
and for the state?
Yes, Your Honor. Abigail Gilpin, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
Okay, is there any victim in this case?
There is.
Then one of the, and was the victim notified?
Yes, Your Honor.
Okay, it's a victim present. You anticipate the victim being present. We're here on a motion to revoke community control. We're set for hearings today on that motion. Has there been any resolution or we need to just start with testimony?
Yes, Your Honor. It's the state's understanding that the defendant will admit the probation violation in exchange for a sentencing recommendation that she have an additional special condition added to her community control that she enter into and successfully complete the treatment at Field of Hope and then remain on community control thereafter.
Okay, anything to add to that, Ms. Bunce?
No, that's our agreement.
All right, if you would then inquire for the admission.
Yes, Your Honor. All right. So, Miss Harris, you are currently on probation here in Meigs County, is that right? Yes. And part of your requirements to being on probation or community control, is it's more officially called, requires you to do certain. Is that right? Yes. Okay. And part of what it requires you to do is to report to the probation department as they are asking to do. And it may be monthly, it may be more frequent. Is that right? Yes. All right. And so one of the things that was filed in terms of the motion to revoke community control, it's alleged that you failed to report for a monthly check-in back in June of 2025. Is that correct? Yes. All right. And you recognize that by not reporting that was violating the terms of your probation or community control? Yes. Okay. And so you then do admit that you violated your probation? Yes. Okay. Thank you.
All right. We'll find that you violated the terms and conditions of community control pursuant to the admission you just made, and the court is prepared to proceed to sentencing as the state.
Yes, sir.
Defense counsel.
Yes, I am.
Ms. Harris, any reason why we should not proceed to sentencing at this point? Or adjudication. All right, with that in mind, the state's position again is.
Yes, Your Honor, the state would ask that the court would go along with the agreement of the parties and sentence the defendant to have an additional special condition added to her community control that she enter into and successfully complete treatment at Field of Hope and then remain on community control thereafter.
Right, and there's no victim impact to take into consideration of the probation, but okay, with that then, Ms. Spence.
Yes, Your Honor. I also would ask the court to accept the agreement of the parties and allow Miss Harris to complete Field of Hope. Miss Harris, I think she's a pretty smart young lady. She's had a few problems along the way, but I think she's learned some things, and this is her first and hopefully last probation violation. She was also on probation in Athens County, and she has completed that. So I think that's a sign that she is able to finish things. And she, I think that according to what she was telling me earlier, that's, I think, part of what happened to make it hard for her and some of her reporting is being at two different places with two different requirements. And so thankfully things are going to be simpler now for her with just one place to report to. And I think if you give her the opportunity that she'll do well. She has family obligations that she's looking forward to getting back to, and so she's gonna try and complete the program as expeditiously, if you allow her to do that, as possible, so that she can get back and help with her father who's been ill. So she's got a lot of concerns about him, and so that's something that she wants to take care of. And so, and I didn't mean to, I guess I got her upset.
Sure, that's why we have cleanup there.
But that is her main concern, is just helping with her family and trying to do the right things here so that this will be accomplished and she'll be a better person.
All right, Ms. Harris, do you have anything to say on your own behalf or to present any information in mitigation of punishment?
No.
So I haven't heard it stated other than it's in the recommendation. Do you have a substance use disorder? Is that a yes?
Yes.
Okay, and that was diagnosed through whom?
She goes to a repeat in Mason.
Okay, so you do have an official diagnosis. Has she been assessed at Field of Hope for admission?
I don't think so, although Miss Lavender was looking into getting her admitted, and it's my understanding that they could take her pretty much any time once I don't know if she needs to maybe go back to Miss Lavender's office and talk with someone to Field of Hope and make sure.
She does usually facilitate.
I thought that's how it worked, and so that's probably what's planned. I would suspect it's a court order, so.
So you continue to struggle with substance use disorder?
Yes.
Okay, and the court has considered reconsidered the purposes and principles of felony sentencing and does find that pursuant to the agreement that a prison term is still not consistent with the purposes and principles of felony sentencing. Instead, you will continue on community control with a new specific obligation or term of community control that you must enter into and successfully complete the Field of Hope inpatient treatment program. And you'll go directly from being an inmate of the Meigs County Sheriff to being picked up by Field of Hope when they have the space available, assuming you're eligible. And they'll take you directly to Field of Hope, and you must obey all their rules and conditions. And only after you've successfully completed that will that term be removed. Also, because you're not going to prison for this time, I do have to tell you though, because you're still on community control, that you if you have another violation allegation, that you could go to prison. And if you go to prison, you may be subject up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You'll also have to pay the court costs in this case. When you complete your time at Field of Hope, you must also come in person within 48 hours to the probation department to get back on the schedule for the reporting. So you're still on probation after you finish Field of Hope. You understand that? And you have to show up for your appointments as scheduled, or you're going to be back in the same situation. And you have the right to appeal this court's decision. Any appeal must be made within 30 days after your sentence. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. All that having been said, I see Brittany's here. Did you hear us talking about her situation?
Yes, she has been accepted. I believe they're going to pick her up tomorrow.
She has been accepted.
Yes.
Okay, great. So you'll be remanded to custody of the Meigs County Sheriff. You'll go back to regional, and they'll go to regional to pick her up. Okay. All right, then anything else? You have any questions, Ms. Harris? All right, good luck to you.
Thank you.
Thanks. Who do we have?
Lars?
Are you having trouble hearing, ma'am? You want to make sure you can hear? Okay. Is he? Is he having? prescription for the Suboxone, or do you know? Okay, it's been verified. Okay.
Other one, just funny.
I'm sorry. Yeah, so obviously we won't be able to do it, so. Well. Odd. I know, yes. but no.
When she, my promotion's in, why don't you go to the jail? Like, here, can do,
Mhm.
you know?
Yeah, that does.
Well, on the pass of the bench, they can't do it, they can. Get to judge. So,
All right, thank you.
all about it.
You ready, Mr. Darst?
State versus Darst.
We are on record in the Meigs Common Pleas Court, the state versus Darst 21 CR 010. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Dan Darst.
And your address was provided along with your phone number and email on a piece of paper. Is that correct? Is the information on that paper accurate?
Yes.
And your attorney's going to identify herself.
Yes, Denise Bunsen, I'm here on behalf of Mr. Darst.
And for the state,
Yes, Your Honor, Abigail Berkeley, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
is there any victim in this case?
Yes, sir.
Was the victim notified? And it is that person here?
Yes.
I thought so. And so she is present. And we're ready to proceed. This is a motion to revoke community control. So with that, is there an agreement? Or are we going to have a contested hearing?
Yes, Your Honor, it's the state's understanding that there has been an agreement that the defendant would admit the probation violation in exchange for a sentencing recommendation. The state would recommend that he serve 5 consecutive weekends in local incarceration beginning August 7th. So we check in Fridays at 5 p.m. and check out Fridays or Sundays at 5 p.m. August 7th through the 9th, August 14th through the 16th.
Wait a minute, 7th through the 9th. And then what was the next one?
The 14th through the 16th.
Okay.
The 21st through the 23rd,
Okay,
28th through the 30th. And then September 4th through the 6th would conclude his time in local incarceration, and then he would continue on community control. I believe he's would be finished with community control October 8th.
will we be completely finished? with
Yeah,
community control?
he'll have been on for 5 years, Your Honor.
Okay, okay. All right, wow, that's just doesn't seem like it could be 5 years, but I understand that now.
That's my understanding. I didn't check the numbers, but
And
I
do we,
believe it.
did you make arrangements to the sheriff's office for this weekend? Because, you know, there'll be extra cost and transportation and such, and it'll have to be coordinated to get him, because we don't have jail here. You can't just go and report to jail here.
I've spoken with Cassidy about it, but I have not spoken with the sheriff's office. If you'd like to have a brief recess, I can get it all coordinated.
Yeah, I would like to have it coordinated so that we know, for instance, if they agree they're just gonna house him in Gal Police, he could check himself, probably, well, I mean, he could check himself in either place potentially. Do you have a valid driver's license? No, okay.
Yes, I wanted to.
Okay, we just need to know where he has to be at each time. And so your victim, which I think is also your grandmother,
Yes.
raised her hand. You would agree to transport him and pick him up? Is that a yes for the record?
Yes.
Okay, that's all right, because we do make a record. Thank you. Okay, with that then, if you would inquire.
Yes, Your Honor. So, Mr. Darst, you're on probation here through May. Is that right? Okay,
You have to speak up.
have to talk nice and loud.
Yes.
There you go. And so as part of your probation, you are supposed to pass drug screens, is that correct?
Yes.
All right, and so I believe in June of this year, which was only about a month ago, late June, you came in for a regular check-in with your probation officer, is that right?
Yes, ma'am.
Okay, and when you checked in, Mr. Wilford had you do a drug screen.
Yes, ma'am.
And unfortunately, you failed that drug screen, is that right?
Yes, ma'am.
Okay. And
Failed for what?
Kratom, a gabapentin.
Thank you. And you don't have prescriptions, obviously, for treated and didn't make out anything, right? Go ahead, Ms. Spice, I'm
All
sorry.
right, thank you, Your Honor. And you recognize that you're not supposed to do that, is that right?
Yes, ma'am.
Okay. And because you, tested positive, that would be considered a violation of your probation terms, is that right?
Yes, ma'am.
Okay, and so you do admit that you violated the terms and conditions of your probation?
Yes, ma'am.
Thank you.
I'll take that admission and find that you violated the terms and conditions of community control, and the court is prepared to move to the adjudication as the state
Yes, Your Honor.
defense counsel.
Yes, ma'am.
And any reason not to complete the adjudication from your estimation, sir? You're ready to go to that stage, okay?
Yes.
With that prosecution's position again?
Yes, Your Honor, the state would ask that the court go along with the recommendation and sentence the defendant to an additional special condition of his community control to have 5 consecutive weekends of local incarceration beginning on August 7th and concluding on September 6th, and then ask that he remain on community control thereafter until it's completed in October.
Right, no victim impact statement, or is there a victim making statement? Okay. And then defense counsel?
Yes, Your Honor. I would echo the recommendation of the state in allowing Mr. Darce to have weekend term of incarceration. It will allow him to keep his employment. He has a good job and he doesn't want to lose it. And he does need the income, of course, to pay his bills. And so this will give him an opportunity to still be able to keep his work, but also, I know, receive a sanction, which, you know, there's always some need for a sanction if you don't follow the terms and conditions of probation. And so I would like to think that this is a fair response to what's going on, and that Mr. Darce will move on from this. And of course, he's not got a whole lot of time left on his probation, and so hopefully he'll move on and do well in his life. And I mean, he does have people here to support him, and so that's encouraging, and that shows that, you know, he does have people that will help him try and do the right things. And so I'd ask you to give him that opportunity.
Mr. Darce, do you have anything to say on your own behalf or to present any information in mitigation of punishment?
I do not.
Okay. I will find that you, as I indicated, that you did violate the terms and conditions of community control, and that I have evaluated and reconsidered the purposes and principles of felony sentencing, and find that a prison term is still not consistent with the purposes and principles of felony sentencing. Instead, you will remain on community control with a new special condition or sanction that you must spend however many weekends, let me look back, 5 consecutive weekends in local incarceration from Friday night at 5 to Sunday night at 5 as your sanction. And then you must report after you've completed the last of those within 48 hours in person to probation to get back on the schedule to know when you have to report between now and the end of your probation term. Also, we'll need to make sure that the sheriff the jails will accept him with a civilian bringing him in, or if we need to have a deputy. I got to thinking about that. Can someone double check maybe with the sheriff's department to see if that's possible, or if we're going to have to coordinate that he has to be here, you know, meet a deputy. I don't know, because maybe you can't just go into regional if you're not a deputy taking you in. I don't know. Same thing, it could be in Gallia. So we need to find that out. Also, you ought to pay the court costs in this case. If you violate the terms and conditions again, like you don't spend those, you don't show up for those jail times, and then you'll go to prison. And if you go to prison, you may be subject up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You have the right to appeal this court's decision, and the appeal must be made within 30 days after your sentence, which is what we just did. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions?
No, ma'am.
All right, then with that, if you'll, I'll have you wait for a few minutes to figure out the logistics of how you turn yourself in at each of those weekends. So did you put a text in or we need to,
I texted Cassidy and he's calling the sheriff's
okay,
office.
did you do something too? Okay, same thing?
Yep.
Okay, that's fine. Great minds there. So just have a seat in the courtroom if you would, and then we'll get you that information as soon as it's available. Thank you. All right, who do we have next?
Windsor,
Okay.
22 CR 138.
Have you guys talked about him yet or not?
We have,
Okay.
there's an agreement, but she was just, one of the conditions of our agreement is Mr. Windsor would go to drug court.
Oh.
And so.
He has to have the
He had went
evaluation.
through his not employer, pardon me, through his care provider. I was talking to someone from there that's with him this morning.
Mhm.
And that person said they also come to drug court, so they
Right.
understand what's required and it's my understanding that Cassie probably would need to get
We usually have the defense attorney go through the terms and conditions of the drug
Yes.
court agreement and the handbook, so we'll need those.
Yes,
Uh,
we can do that afterwards. I've gone through this many times.
Okay, so I want to make sure you completely understand all
Here
this.
for a while, so it's good.
Okay. All right,
State versus Windsor.
Oh, yeah. He filled it out, just balance. Oh, and I've got a progress report that was
Great.
brought for him too this morning from Shawnee Kelsey Center.
did you find the address?
Yes,
Okay.
Jim's got it.
All right, we are on record in the Meigs Common Pleas Court in State versus Windsor, 22 CR 138. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
State your name
Robert Windsor.
and your address, phone number, and email were provided in writing. Was that information accurate?
Yes, Your Honor.
Okay, and your attorney?
Yes, Your Honor. I'm Denise Bunce and I'm here on behalf of Mr. Windsor.
And for the state,
Yes, Your Honor, Abigail Gilfie, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
is there any victim in this case?
No, Your Honor.
Other than the state, of course. So we're here on a motion to revoke community control. I understand that there was an agreement. Listen carefully. The agreement's going to be explained on the record, then you'll be asked some more questions.
Yes, Your Honor, it's the state's understanding that the defendant will admit the probation violation in exchange for a recommendation that there be an additional special condition of his community control that he enter into and successfully complete the drug court program, as well as complete his current treatment at the Shawnee Counseling Center and then remain on community control thereafter.
And I assume pay the cost.
Yes.
Okay, defense counsel?
Yes, that's what our agreement is, Your Honor.
Okay, so Windsor, do you have anything to say on your own behalf or to present any information in mitigation of punishment?
I just appreciate the opportunity you guys have given me to, work on myself
Good.
instead of just giving up on me.
And we don't want to do that because I know we've been through a lot. You've been hanging around here since I've been judge. So it's like, we really want to see you do well. So anything else you want to say?
No,
The court has considered and reconsidered the purposes and principles of felony sentencing and finds that a prison term is still not consistent with the purposes and principles of felony sentencing. Instead, an order that you remain on community control, but that you have a new special condition that you must remain at and successfully complete the Shawnee Counseling Center program, and that you also enter into and successfully complete the Meigs County Common Pleas Court drug court program, which means during the period of time you're at Shawnee, they'll help transport you here for that. And then if you graduate from Shawnee before you're done with drug court, then you'll have to get yourself here to successfully complete the drug court. In any event, once you're no longer living in the housing, sober living some step of the Shawnee Counseling Center, you must report in person within 48 hours with probation department in person to get on the schedule and make, of course, you're going to see him every every Monday at drug court. But your key is you got to get back on the schedule for reporting in person once you're done with Shawnee. Also, you have to pay the court costs in this case. And if you would violate the terms and conditions of community control again, I think you have a substantial amount of time hanging over your head. You could go to prison. If you go to prison on a later motion to revoke community control, I need to notify you may be subject to up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. I think I already said that you have to pay the court cost, and you have the right to appeal this court's decision, and the appeal must be made within 30 days after your sentence, which is what we just did. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions?
No, Your Honor.
Okay, do not leave until you go through and I mean like word line for line, word for word, because it's important that you understand what exactly you're signing up for with drug court, and that you go through the handbook so you know what the steps are, that each of the phases and so on. And where are you at Shawnee? Which is he where he would be able to start coming to drug court next week or? Okay, I know he's been there for a little while.
Yeah,
Okay then. And I don't know if Cassidy came in, but if somebody in probation, if they're listening, and I think they are, could get that paperwork ready, Ms. Spence will go through that with him. Do you have any questions at all, Bobby? All right, then we can go off record. Thanks. And
Judge, is you gonna do that now or?
And if I get them, I'll go over them.
yes, as soon as she'll have time here, and then I want to put something on the record. She'll have time between now and her pre-trial with, I think that's Mr. Dalton.
Mr. Dalton.
Yeah, so she'll have time to go through that before she meets with Mr. Dalton. I do want to tell you, though, that we did have someone that's coming up for a hearing, still test positive.
With the mayor, and
Yeah.
it's not Denise's, that is Robert.
Oh, okay, I thought that was Denise's.
Yes.
Yeah, so she's not, we need to tell Mr. Roberts. Yeah, I'd like to see it.
Mr. Darst in jail.
Yes.
So
I can't
the jail will take him. Him going to the jail, so he doesn't have to come here, he can report to the jail. The jail said that he needs to probably report at 4:30. Because they do 24-hour increments, so if he reports at 5 but doesn't get booked until 5:30, he wouldn't get out till 5:30 on that Sunday. So a little early is better, just make sure that doesn't bring anything stupid into the jail.
Where do you work?
Yeah.
Indiana. So what time are you usually home on Fridays?
I'll come home Thursday.
Oh,
That way he'll make sure that.
okay, that's fine. And that's easy for you to be there, 4:30 to 4:30.
Yeah.
Okay.
Can I ask what this GPS keep going?
Yeah.
No, he's good with it now.
Oh, okay, you don't want him on it now?
No,
Okay,
I'll
that's
take it
fine.
now.
Make sure, as Mr. Wilford said, that you know you can't take any contraband into the jail. Obviously, that would be a new felony, and to make sure you're. And I see that you did test positive for Suboxone, and I trust you received the current prescription for that. Okay.
Yep.
So that's good, and make sure you continue in your treatment. If you need some substance use disorder care, that you continue with that. All right, thank you very much.
And you're wanting us to go over the paperwork with Windsor.
Well, Denise and you, or I don't know who, I want her to go through it, and then probably you and have him initial it all, because I'll make sure he understands all the terms. Because there's a lot, I mean, it's a lot of stuff.
So you want to print it all out for?
Yes,
Like
please.
20 pages, I remember.
Yeah, there's a lot. Do you need this copy back from Shawnee? I'll get it back to you in just a second.
It would be good for him to go to Cassidy probably, since he's on probation with him, that way he'd see.
But do you need us to make a copy of it, or is this your only copy?
It's my own copy.
We can get a copy, no, that's no problem.
We'll take back so you can finish his lunch.
Okay, that's fine, yeah.
So.
Right. We'll need to make a copy of this and give Denise. We'll go off the record. And the next two are pre-trials, right?
Yes. Are you gonna go?
I don't
Are
think,
you there, right?
I know, I don't know if I mean, that would be really pushing it. I hate to walk in a funeral late.
Oh, you wanna go to the actual funeral, not the viewing?
If it was the viewing, I could be fine, but the actual
Yeah.
funeral starts at 11. and I
Okay,
knew that would
get
be-
what you're saying.
That would be really pushing it.
Yeah,
Yeah.
I get that.
Nice to see ya. Oh, he didn't say which jail. Cassidy, which jail? I'll watch for a message. He heard me. Hey, Jim, can you find out which jail Mr. Darst is supposed to report to?
Southeast Regional.
Okay,
I asked Cassie which jail.
so do you know where that is? That you know actually where the jail's located in Nelsonville? Oh, okay, been there, done that. Okay, yeah, don't do that anymore.
Oh. Feel like that one being the, oh, she must be done for the day. No, she's not. Yeah, I know. Okay. You don't know. Alright, I don't need my heater.
I'm here.
I won't be here.
Where you going?
Well, I mean, not until after lunch.
So can I just go ahead and give you these?
Yeah.
Oh, I didn't bring the. All right, Mr. Roberts, do you want to speak to your clients in breakout rooms before we bring them in?
So just so that I understand what we're doing here with Nur, we're not gonna be able to do anything today because she's still positive.
I'll have to ask the judge to be sure.
Okay.
Okay,
Okay.
what about Poolins?
Pullins, the prosecutors are in agreement with him going to treatment. He just needs to get a bed date, or get screened for that. He's all on board with that already.
Okay, and I did an order this morning that should have been filed for our probation department to do a phone assessment with him to try
Okay,
and find him
cool.
placement. So, okay, I'll have him come on in then, and then I'll have the judge come out.
Perfect.
Okay,
Thank you.
you're welcome.
Third house file, don't work that, nope, 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 keep going straight. There you go. Your accounts on Zoom, you should be able to see them right here. Sir, I have to take your hat off and forth, please. Thank you. Is that remote at all? You got no cramp, you got no- All rise, please.
Thank you. Please be seated. Hi, Mr. Roberts.
Good afternoon, Your Honor.
We'll start with Ms. Kinnear,
Kinnear.
not Near. Sorry, I knew that, or I said it, sorry.
We're on record?
We are on record in the Meigs Common Pleas Court in State versus Kinnear, 26 CR 008. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Morgan Callahan, Kinnear.
You have to speak up.
Morgan Kinnear.
Okay, and you provided your address, phone number, and email on a piece of paper before I came in, correct?
Yes, ma'am.
And was that information accurate?
Yes, ma'am.
Okay, and your attorney for the record,
Lee Roberts here on behalf of the defendant.
appearing by Zoom with consent from your client, correct?
Yes, ma'am.
And for the state,
Yes, Your Honor, Abigail Gopi makes Common Assistant Prosecution Attorney here on behalf of the state.
is there any victim in this case?
No.
All right. We're here because we were scheduled last week for, I forget, was it a change of plea last week that we were supposed to do? But Mrs. Kinnear tested positive for a number of illegal substances. Unfortunately, today she continues to test positive for fentanyl. So we certainly can't do the change of plea, not that we're necessarily planning on doing that, but I don't know that we can even have a meaningful bond hearing, except I understood that Mr. Roberts was asking that she be able to go to an inpatient care facility, and certainly would like to see her get help if she has a substance use disorder, and if she either used so much fentanyl that it's still in her system or somehow had access to it when she shouldn't have, then obviously she does need that care. Have you been able to try to find a place for her?
I believe that she has a bed date already at the Recovery Council.
Okay, when?
As soon as you order.
Okay, I mean, beds are sometimes taken, but you believe
They told me that once I had the judge's signature, get back to them and they'd be able to come get her.
okay,
Yes, and I had asked him for an agreed entry, and that was file stamped today.
Okay.
So
okay, that's fine
it's
then.
been filed.
Does the state have any objection to that?
No, the state has no objection.
Okay. Because we're not actually taking a change of plea, I'm gonna go ahead and do this, at least the bond hearing today, and get her someplace where she can get help. I do want to make sure you understand, however, by giving you a new bond that's an OR bond, which is what this will have to be, it'll have special conditions. One will be the special condition that you go directly from being a Meigs County Sheriff's inmate to being picked up by and transported to the Recovery Council, and then you must remain there until further order of the court. So if you leave there, you're going to immediately be arrested in a very high bond set. You understand that?
Yes, ma'am.
Okay, so you must remain in and successfully and cooperatively complete that program while this case is pending. Also, you must be advised that because this is an OR bond that you're getting with these special conditions, and the underlying charges are felonies or a felony, an OR bond means if you fail to appear at any scheduled hearing after you sign that, you could be charged with an additional felony. Do you understand that?
Yes.
Okay. Also, as I told you the first time you were in here, you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do those things with firearms, and can't get any other trouble. No contact with law enforcement resulting in charges or arrest. Do you understand those conditions?
Yes, ma'am.
Okay. Several times you've had a little tremor. Is that because you're cold or something going on with you neurologically?
I'm cold.
Okay, I've just seen you do it several times, and I thought, one time is, okay, I got a little bit of chill, but you did it a bunch, so you're okay?
Yeah, I'm good.
Okay, I just want to make sure. I don't know if anybody else saw that, but you saw it, didn't you? I was like,
Is that cool?
okay, that's the only reason. So, and then our next hearing, do you want to have a status or go ahead and give her a little bit of time at the Recovery Council and then try to do the change of plea and make that our next date?
I would recommend giving her some time at the Recovery Council.
And then scheduling a status hearing or a change of plea hearing after she's been there a little while.
And a change of plea.
You agree, Mr. Roberts?
Could we schedule it for a status, Your Honor? The goal had been to get my client into ILC as part of all of this. And I just want to make sure I've got enough time to get the assessment with her being in treatment now.
Well, but last week, yeah, when she came, I thought you had already lost that opportunity when you came last time, or was that going to be an ILC last time?
It was going to be an ILC last time.
And did you already have the assessment? Because I don't think I had seen the assessment.
We didn't have the assessment. I had talked to the state the last time, and they were willing to continue it once more to give her an opportunity to get an assessment. And then we had the bond violation issue.
Okay. All right, let's do a status and a change, and then a change of plea after that.
Okay, so if we give her a month, like the month of August in treatment, what do you have available that first week of September, Mr. Roberts?
And we really want you to actually look at your calendar and not say, yeah, that's fine, like you did.
Oh, I don't ever do that.
Oh, on Haining you did.
I don't think I agreed to that court date. I that date was set with me.
You
and
were
I
on
didn't-
here. We had you with her for her Raymo. It was when there were a bunch of people on Zoom at the
Okay,
same
I
time.
may have made a mistake then, Your Honor. I
Okay, I just
apologize.
want to make sure, because we do have a different attorney that will just say yes and then immediately turn around and file a motion to continue.
That's not normally what I do. Something
Okay,
must
cool.
have
That's great.
happened there.
I just wanted to give you a rough timing to make sure you didn't.
Looks like the 2nd of September, I've got one thing in Vinton County at 1 o'clock, but otherwise I'm free. Want to do the morning?
You have grand jury that day, but do you think somebody else can cover
Why
this
not?
hearing? Okay, so, okay, do you wanna have it in the morning here then? Or the afternoon?
Please.
Okay. Well, we have the whole day open, so you tell me what time.
How about you guys start at 8:30? Why don't we start at 8:30?
Well, we actually started at 8, if you want to come at 8.
Okay, let's start at 8 then.
Okay.
Alright. So that is September the 2nd at 8.
Then let's go ahead and have a change of plea 2 or 3 weeks out from that. See how, give her some more time and treatment and make sure she's serious about it.
Right. What about? What do you have the last week of September? Yeah, the 30th.
Give me
We have that whole day
one
open.
moment. You said the last week of September?
Yeah. What about September 30th? We have that whole day open.
Me too.
All right, perfect. What time?
Want to do first thing in the morning again?
Sure. September 30th at 8 a.m.
All right, anything else we can do on Miss Kinnear?
No, ma'am.
All right, we'll put you back in the jury box and we'll switch you for Mr. Pullins.
You probably know this, but she actually has a different name now.
Oh, I do. For the record, she told me that last time and I almost mentioned it. What is your last name now, Miss Kinnear, now known as?
What did you say?
What's your name if you go by now?
It's Callahan, Callahan.
Okay, thank you. We should make a note of that because that's your legal name now, even though it was indicted under Kinnear.
Yes.
Okay, thanks. Thanks for reminding me. As soon as they can get her to get you, I don't know if that's today or tomorrow, but it'll probably be either later today or tomorrow. As soon as they can come get you.
Thank you.
Uh-huh.
Oh, I don't know. No.
State versus Poland.
We are on record in the Meigs County Common Pleas Court and go ahead and have state versus Poland 25 CR 124. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, state your name
Gregory Pullins.
and you provided an address, phone number, and email in writing. Is that correct?
Yes, ma'am.
Was the information on it accurate?
Yes.
And you have an attorney who's present by Zoom and he's going to identify himself.
Lee Roberts here on behalf of the defendant.
Okay, and for the state,
Abigail Bilkin, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
is there any individual victim in this case?
No.
Okay. And we're here because last week, again, we were scheduled to try to do something a little more productive than just have Mr. Pullins appear, but he's tested positive for illegal substances, so we weren't able to complete the process. So today is set as a bond hearing. Does the state have a recommendation on the bond?
Yes, Your Honor. I do believe that defense counsel has filed a motion for defendant to go to treatment. The state's not in opposition to that.
Okay, so you want to address that, Mr. Roberts?
Yes, Your Honor. We would ask that a OR bond be granted to Mr. Pullins so that he can attend an inpatient treatment facility as well. And speaking prior to going on the record with your staff, I believe that a entry has already been done or is in the process of being done to have him screened by your probation department tomorrow. Would just ask that he be placed in whatever treatment facility that your probation department thinks is best. I've discussed this with him. He's open to treatment, willing to do treatment, and is not picky about where he goes. Wants wherever the court deems necessary. Mr. Pullins has a couple of dogs that he lives with that he's very concerned about. We were able last time to get, I think, somebody to take care of him. But he's very focused on achieving sobriety and getting back to his dog. So I think he's going to be, he's got something to keep him motivated. That's for sure.
Okay. Do you have somebody here in the courtroom with you supporting you today? Or any of you here for Mr. Pullins? Okay, that's what I thought. So are you familiar with his dogs, ladies? Are you able to make sure the dogs are cared for so that's not a reason to leave treatment or avoid treatment or try to get done early, correct? Okay, so Mr. Roberts, there are two wonderful women here that say they know and can take care of those dogs. But I know he wants to get
Love
back to them, but in the meantime, because I offered to call the dog catcher if we needed to, but when I saw you guys, I thought, you're okay with them taking care of them, the dogs? You have to answer out loud.
Yes.
Okay, that's great. So there are a number of treatment facilities that we regularly use. We get good feedback from them and have had good success. So if you have time today, we'll have you go ahead and sit down with probation and start doing some assessments. I just want you to be aware that there are both faith-based facilities that have beds sometimes and sometimes are full, and there are non-faith-based facilities, likewise, sometimes with beds available, sometimes not, and that you're not required to go to either type. You might want to just, whatever your preference is, at least try to get in whichever preference you like first, just to make sure that there is a difference. So do you have any questions?
No.
Okay, so your bond will be that you remain in the custody of the Meigs County Sheriff until such time as you are accepted into and picked up and transported by an inpatient treatment facility approved by the probation department. And you'll go directly from being an inmate to that inpatient care. You'll sign all the necessary releases so that the probation department and pretrial services people get updates on your cooperation, your progress, and so on. And that you have to understand, once I have you sign this new bond with these special conditions, if you fail to show up at any scheduled hearings, you could be charged with an additional felony. You understand that? Also, if you would leave that facility and not complete it, there would be a new warrant issued for your arrest for violation of the terms and conditions of bond, and a very high bond would be set. Also, the conditions continue to be that you cannot use drugs, alcohol, or other mind-altering substances. That was one you apparently had an issue with last week. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms, and can't get any other trouble. No contact with law enforcement resulting in charges or an arrest. Do you understand the conditions? Okay, and then we'll schedule what type of hearing, Mr. Roberts, do you need for him?
I believe a change of plea will be appropriate.
Okay.
We were prepared that day, but for this drug test, so I think a change of plea will still be appropriate.
Okay.
Could we do
Assuming
it?
that that's still the agreement. Okay.
That would be fine.
Okay. So let's go ahead and again give him a little bit of time to get oriented where he's going to go.
Do you want to use that September the 2nd day, give him a month in treatment, and then have his change of plea right after Morgan's status?
That was you read my mind.
All right, so September the 2nd at 8:30.
And we need to make sure it's a treatment facility that can transport you here. When most of the ones that they'd be working with do that for us all the time. Okay. Any questions? Anything else from the state?
No, Your Honor. Thank you.
Mr. Roberts, anything else?
No, Your Honor. I did solve the Beverly Haining where you were curious what happened with that. It is a mistake on my end. I looked back at my calendar and I was out of town right beforehand, and I had a stack of mail about this thick that I had not updated. So I had those court notices predating when I set you.
Well, I knew when you asked for it, it was predate. The other ones were predated, but then we wanted to give you rough time because, as I said, another attorney who shall remain nameless is really bad about that, and I think we've got him straightened out now.
I try to be really good about it, so I apologize. I try to, once I set a date, never continue it, but I do screw up from time to time.
We know those
I am
things happen.
fallible, but just wanted to let you know that's what was going on, and have a good rest of your day, Judge.
Okay, well, do you need to have any communication, or ladies, do you have any questions about what happened here, since you're going to take responsibility for the dogs? Anything?
No.
Okay, great. Thank you.
Judge, I did give them Mr. Roberts.
Thank you, Judge.
Oh, okay. His helpers have your business card in case.
Okay, if you need anything, give me a call.
Sister.
His sister, his people. I said his people, his women, not his women. I shouldn't say it that way because it's not. His sister and his
Girlfriend.
girlfriend are here. That's who's here. I thought you were a
Okay.
sister. I figured, but the name, you know,
Yeah.
but I wasn't sure. So if you have sister and girlfriend are here in case they could reach out to you. All right. If nothing else, we'll go off record.
Thank you, Your Honor.
Thanks. Take care.
You too. Have a good day.
All right. Who else do we have? You can go back over here if you want. We have Griffin, but is Griffin here?
Yes.
It's,
For attorney is.
oh, it's Denise.
Yeah.
Okay. Are the victims in the Griffin case?
Yeah.
Oh, I'm sorry. I just say, so we're not gonna be waiting on that person. So as soon as we can find Denise, if we want to reach out to her. You guys wouldn't have to necessarily wait since there's not a victim. Are you here on that one, sir? Are you here for the next case? Were you here on his? Okay, can we help you? Are you? What's your name? I'm sorry.
Anderson.
Wonder what you. I just didn't see you on the docket. Oh, yeah, you do. Never mind. You have an initial pre-trial. I'm sorry. It had already gone past the scheduled time. Have you met with Miss Bunch yet? Okay. Well, it was scheduled for 11:30, so I don't know.
But that's on that day.
Yeah, it is gonna happen. Have a seat. We just don't know why she's not here yet. That was nearly an hour ago. So did she leave without talking to him?
I don't know. I know.
You didn't talk to her?
No, I'm not the.
Oh, you're not the person.
No.
Oh, okay. She may have already talked to him then. I don't know.
I thought he was incarcerated, but I know she wants to go on the record.
Okay, so when was she gonna do that?
I don't know, I don't know.
Is she still back there with people? I don't see her with anybody. Oh, yeah, she is back there. So have a seat. I do see her with someone. I take her back. Whatever she was doing though, she's now ripping it apart, a piece of paper, like it was something that she signed and then don't sign. So we'll send someone back to bring them in. I don't know where. He's coming back in.
The brown door.
You gonna get Miss Butts in here?
Yes, it's. Supposedly right behind.
Who's she talking to back there?
Anderson right now,
Okay,
and she was with
Dalton.
Dalton.
And
You said that you think she's gonna be worked out with. Listen.
all right. Nobody's there. It's just making noise. It was just locking up, Jim. That was just the noise for it to lock.
Yeah, I know, I just thought maybe I might catch her.
Oh, she's back. She's back in the jury room. She's back in the jury room. So we're ready on Mr. Griffin and on Mr. Anderson if you want to tell her that. Or have you already done that?
I did.
Okay. I understand.
This is that extra 5 minutes that continues. When you tell Robert she's gonna put him in the penalty box.
Yeah, he'd understand that, the penalty box. Is that what you were saying? I
Yeah.
couldn't understand you.
Penalty box. Didn't say that when you're on record, but
Oh, it's okay. He wouldn't mind it. I don't think. But you told Denise that she's back in that room.
yeah. She was supposed to be right behind me.
Well, and there's someone on Mr. Anderson's case that's too, that's been here since it was scheduled at 11:30 and now it's almost 12:30.
Mhm. Yeah, well, she's actually had pretty much all day.
Oh, yeah,
with. Then, I mean, she did,
yeah, we got a bunch of them worked out
Oh,
early. Oh, fine.
here
Here
she
she comes.
Just-
We'll leave Mr. Anderson here, I suppose, for now.
she could just learn to use 5 words instead of 50.
It could be that Mr. Anderson could come out and be at his, and then I'll let her choose which one's quicker. Because Mr. Anderson has family or friend or somebody here, and they've been here for a long time, so. And
Sure.
his is a, PV, so it may take a little longer, depending on what she wants to do on record for Mr. Anderson.
You want me to take him with me? I don't.
Oh,
live in
that's
here.
true.
You come with me, sir.
Yeah. And tell her, we've got 2 people that we need to take care of.
Yeah, I'll just bring all. We got Dalton, Anderson and him left, right?
But I don't know if Dalton probably doesn't need to be on the record, but yeah,
Okay.
but those have gone to past time. It is obnoxious. So we're gonna get one just like this.
Oh,
And so it will always be, and they'll be labeled, one's Chambers door and one's gonna be there that you can let yourself in and out. If you need to. Otherwise, you'd have to go through that. Cause they'll be up here like the remotes, it's always available. And I think there's several seconds between the time you push it and the time it remagnetizes, and then we can even vary that by longer if you need it. There they come. You lose Mr. Anderson?
yes, it's Mr. Anderson's an initial pretrial.
Okay, you don't, I thought somebody said you wanted to be on record for him though.
I have a conflict with him and Mr. Dalton. I didn't know if we need to put that on the record or not.
Yeah,
Or if you want me to file a motion.
no, we'll put it on because we need to get in new, which one, are you gonna get new attorneys for both? Okay,
Because what happens is I've represented the victims in both cases.
okay, then we'll need to have.
I
them
didn't
come
know
in.
how we were doing it. I'm sorry. Jim asked me
Okay.
and I wasn't.
I didn't
sure
know what the
was going
record
on.
reason was,
Okay.
so yeah, we'll need them.
Yeah.
And nobody's going anyplace.
And they
until-
gave me discovery before I
That's when you realize
verified
that.
and I found out for sure. And so, I went ahead and made a copy of the discovery and gave it to them and went over it with them because I wanted them to at least know what's going on.
Okay,
And told them that I had a conflict, but the one guy, I'm not sure he understands what I'm saying.
okay, well, we'll bring him in and try to do it on record. This is Mr. Griffin,
Yes, and we have an agreement on his probation violation.
thank you. Right, we are on record in the Meigs County Common Pleas Court in State versus Griffin, 21 CR 082. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, Mr. Griffin. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I swear.
State your name,
Chad Goodman,
and did you provide your address in writing?
I did.
Is that information accurate?
Yes.
And your phone number and email as well. And your attorney is going to identify herself for the record
Hi, yes, good afternoon. I'm Denise Bunce. I'm here on behalf of Mr. Griffin.
and for the state.
Yes, Your Honor, Abigail Gopi, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
And there would have been a victim or victims in this case. You indicated for on record that there was a victim, however, that victim is now deceased. Is that correct?
Yes.
Okay, and there's just the one victim? Okay, so we'll go ahead and proceed. We're here today because of the motion to revoke community control. And I understood, again, before we're on record, that there has been an agreement. So listen carefully. The agreement is going to be outlined on the record, then you'll be asked some questions. So what is the agreement?
Yes, Your Honor, the agreement is that the defendant would admit the probation violation in exchange for a recommendation that he spend 180 days in the STAR program and successfully complete that program. And then at that point, he would be discharged from community.
Okay, anything to add to that, Ms. Bunce?
No, that reflects our agreement.
All right, then, if you would inquire.
Yes, I know. So. Mr. Griffin, you are on probation, I should say, pardon me, here in Meigs County, is that correct?
That's correct.
All right, and you've been on probation for a little bit of a time, right?
It's question two.
Okay, yeah, quite a while. So you have certain obligations of being on community control, including reporting to the probation officer, not failing drug screens, that sort of thing. Is that correct?
It's
All right. And in fact, they did file to say that you had violated the terms of your probation. And was it for failing to report? Is that correct?
I believe it was for positive appearance or.
Is that what it was? Okay, thank you. I thought I had all the information I needed and I looked and I did not. And I knew you would know because it's very personal to you. So you recognize that passing drug screens is part of what you have to do to be on probation.
Yeah.
Okay, and so do you recall exactly when you did fail your drug screen?
There was one in April and one a couple weeks back.
Okay, so back in June or early July?
If you need the dates, I've got the motion to revoke community control on here. That the allegations are that he's had multiple setbacks and relapses during his time on probation. On May 11, 2026, during a phone call, he stated that he had relapsed May 4, 2026, and was going to be his last chance with the program, and he needed to take it seriously. And then on July 1st, 2026, he was probation was contacted by the Ford Health Ohio LLC, and that Mr. Chad Griffith had again relapsed with methamphetamine and moved back to the partial hospitalization program, and that he continues to use illegal narcotics and is in direct violation of the terms and conditions of community control. Since you didn't have it in front of you, those are the allegations.
Thank you, Your Honor. I believe I've read it, but I've read a lot of things.
I understand. That's why I thought, yeah.
So I don't recall and I didn't have it in front of me. Thank you. So Mr. Griffin, having heard the judge recite the information that was on the probation violation, do you admit that the allegations they indicated were true, such that you admitted to having a positive drug screen and having taken illegal substances in the time frame they indicated, which was in May and July of this year?
Spot on that. That's decimated my life.
I'm sorry. Speak up a little bit.
Methamphetamines it's ruined my life time and time again. I don't understand the compulsion to use it. And I knew that prison time was on the line and I still decided to, it's insanity to me. I struggle with it. You know, I feel like I got it and then temptation's there and I get into it. And I'm sorry. The information's accurate.
Okay.
And you were in a program actively involved in the Ford Health Ohio LLC rehabilitation program, correct? And had been for some time.
Since August.
Okay. August of 25. Okay. Oh, go ahead.
All right, thank you. And so, having failed a drug screen for methamphetamines, as well as making an admission to your probation officer that you would fail for another drug screen, do you recognize that that's a violation of your probation?
I do.
Okay, and you therefore admit that you were in violation of the terms and conditions of your probation.
I do.
All right, thank you.
I'll find that Mr. Griffin did violate the terms and conditions of his community control sanction, and that as such, the court is prepared to move on to the adjudication or the sentencing sanction phases. The state,
Yes, Your Honor.
defense counsel,
Yes,
Mr. Griffin, any reason why we should not move on to the adjudication stage of this proceeding?
No.
Okay, and state again is asking for.
Yes, Your Honor, the state's asking that the court go along with the party's recommendation and sentence the defendant to have another special condition of his community control. That being that he spend 180 days in the STAR program and successfully complete that program. And upon successful completion of that program, discharge him from community control.
And there's no individual victim impact since that person's deceased. So defense counsel.
yes, Your Honor, I also would ask the court to accept the agreement of the parties. And allow Mr. Griffin to go into the STAR program. I think he, when he and I were speaking earlier, he recognizes that this is of sanction and it's not going to be easy, but he is grateful to get this opportunity as opposed to, as he said, going to prison. And he recognizes that's a big period, I guess essentially not a period, but it's a grace move, and he's very grateful for being given an opportunity to try to start his life over. He was just talking to me a little bit ago. He's worried about paying his child support as well, because I guess he has an order for child support through Meigs County here. And that's another thing he was wondering about, and I don't fully know exactly what happens with those 180-day programs at STAR if you work or anything. So I couldn't say, but I know that is something that he would like to see happen as well, that he is able to try to meet some of his responsibilities, even though I think he's pretty clear in saying that he messed up. And that
Was he working at the time of these relapses
Was
and paying
Yes.
child support through withholdings or paying it directly?
paying directly.
And where were you working?
Quality Property Services, a demolition construction company.
Out of Columbus?
So
What else did you want to say? I didn't want to cut you off.
it's all right. I was just gonna say that I would ask the court to accept our agreement and allow him to go to STAR. I mean, it sounds like he acknowledges that he's got a problem, and I'm hoping that going to STAR will help him to adjust to the things and maybe figure out some things that are going on, some triggers and that sort of thing, that maybe he can have a better chance of sobriety once he gets out of STAR and starts his life over.
Thank you. Mr. Griffin, do you have anything to say on your own behalf or to present any information and mitigation of punishment?
No,
Okay, we'll find that pursuant to the agreement and the re-review of the purposes and principles of felony sentencing, that a prison term is still not consistent with the purposes and principles of felony sentencing. Instead, per the recommendation, the court is going to sentence you to a new condition of your you will remain on community control, and as a new condition, you'll go directly from being Meigs County Sheriff's inmate to be picked up by and go to the STAR program, and that you'll have to complete a full 180 days at the STAR program, which is still substantially less than what you'll be facing on your felony 3. And you have to comply with all their conditions. They're very strict and a lot of rules. There are opportunities there for trade trainings, there's welding, electrical, plumbing, food service, administrative work. There's a lot of things you can do there. And heating and cooling, HVAC. I don't know, I don't believe you're paid during that though. So I would caution you that you do need to put in writing with the Child Support Enforcement Agency that you're currently incarcerated as a Meigs County inmate, that you'll be going to STAR and you'll be there for a period of 180 days, so that they're not trying to file contempts and try to find you during that time. That doesn't mean they won't as soon as you're out file contempt, but if you show them you're back re-employed and after you're out, I'm sure that that would be a lot better if you're actually get reemployed right away, and hopefully you can. But I would let them know. The key is communicating with child support enforcement, not ignoring them, and that does help a lot. Now, if you would not successfully complete the STAR program and not do the whole 180 days, then there would be another motion to revoke community control. And because you do have such a serious offense, and it started out as a felonious assault, went down to attempted felonious assault, which is a heck of a deal, you still have those 3 years hanging over your head. So if you don't complete successfully the STAR program, you're going to prison. And if you go to prison, then you may be subject up to 2 years of post-release control under revised code section 2967.28. If or when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You have also have to pay the court costs in this case. You'll get credit against the full sentence for the time you've been awaiting this hearing in jail, and then you'll still have to do the full 180 days. You have the right to appeal this court's decision. Any appeal must be made within 30 days after you're sentenced. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions?
No.
Okay, I don't know if we have a dead date. I'll look and see if we have any messages. Yeah, I don't have anything on.
He hasn't filled this-
Typically, the bed date is going to be, if it's not this week, it'd be certainly next week. They pick up pretty quickly. And there's only certain, are you a Southeast Regional?
I am.
There's certain days they pick up at Southeast Regional, a different day they pick up, yeah, again. different day.
Probation said they're working on it.
Oh, they're working on a date for you. So probably before you leave, we'll have a date for you. Because we're gonna talk to 2 other people that are here in Orange. So if you go back, maybe we'll switch with them, we may know before you leave.
Okay.
So anything else from council?
No, Your Honor.
Okay, we'll send you back to the sheriff's department.
You need Dalton and Anderson.
One at a
Yes,
time.
Jim,
One at a
didn't
time.
know.
That's okay.
Yeah. So what the situation is Andrea gone?
Yeah.
Okay, so both of Ms. Fence's defendants, Dalton and Anderson, are cases where she cannot represent them due to conflicts. So we're gonna have to get new attorneys and new dates for both of them.
It's kind of unusual that I have,
Too.
but I mean, and in one of them, the lady even said, I heard that you're representing blah, blah, blah.
All to you?
You have a conflict, I think. And yeah, it was telling me about it. So
Okay,
I was
well,
like, okay.
At that time, you
So,
didn't have any discovery, so you wouldn't have done that.
So I read it, then I said, oh, yes, I guess that might be, they could be called as a witness potentially, so.
Yeah, if they're a victim.
Yeah,
certainly.
the other one that,
Another one's also a victim. Yeah.
yeah,
Represented.
well, they're like. They were present and they're listed in the, information and.
May have to be
Police
testified.
report, all that sort of stuff, and detention could be called as a witness.
Do either one of them have co-defendants? Or they all stand alone?
No, I don't think so.
Okay, so we can do whomever else.
Uh.
I just wanna make sure we don't, and then
Yeah, the one
another-
guy told him and he begged me to they can just keep his case, and I'm like,
I cannot,
no,
not
I can't
allowed.
do that, buddy, I don't have
Mhm.
a conflict, no, that's not how we're. And I said, listen, any other lawyer will do fine, they'll probably do better, trust, it'll be all right.
Mr. Anderson, right?
Just walks toward the door. All the way.
I come on in front and go over there around that table and have a seat with Miss Muntz.
We'll fix his leg irons before we leave. They got him on back.
Oh. Makes it hard for him to walk, probably.
Chain on the outside.
Oh. Yeah, that doesn't make sense. This is Mr. Anderson.
Yes.
Are we on record?
Not yet.
Not yet, okay. I'm gonna try.
So, no.
We are on record in the Meigs Common Pleas Court and State versus Anderson, case number 26 CR 059. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, sir. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you
Yes.
God? Tell me your name,
Thomas Franklin Anderson.
and you provided your address, phone number, and email on a separate piece of paper. Is that correct?
I have none.
Oh, you're homeless?
Yeah.
Okay.
I was renting that place and I lost it.
Okay, so, but you're currently housed where?
Oh, yeah.
You're at the Southeast Regional Jail, so we'll make sure all your correspondence goes there. And your attorney's going to, your current attorney, which we're gonna talk about, she can't continue, is,
Yes, Your Honor, I'm Denise Bunce and I'm here on behalf of Mr. Anderson.
and then for the state?
Yes, Your Honor, Abigail Gilpey, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
And there would be a victim or victims in this case?
Yes, Your Honor.
Was the victim or were the victims notified?
Yes.
Are they present?
No, ma'am.
You expect them to be? Okay. Mr. Anderson, your attorney that we appointed for you, Ms. Bunce, has indicated now that she has seen the discovery that she has what's called a conflict of interest. She's not going to be allowed to help you through the rest of the process because of she's represented or maybe continuing to represent someone that's listed in your discovery. So we're going to have to get you a new attorney. You understand that? You have to answer out loud.
Yes.
Okay, and so that's really all we're gonna do today is get the new attorney and give you new dates. What attorney are we going to appoint for him?
Britt Wiseman.
We'll appoint attorney Britt Wiseman, and we'll give you his business card. His information will also be on the entry from today that tells you that he's gonna be your new attorney. Because he typically is here a different day of the week than Ms. Bunce, we're gonna also reschedule hearings to be different than you have in your original order. But they also still have to be very fast because he is incarcerated.
Yeah. Okay, initial pretrial. August 10th at 1:30. Final pretrial motions, August 31st at 2:30. And the jury trial. September 15th.
Are you also at Southeast Regional? You said, you did say that. So they have a way for you to be able to talk to your attorney. You should be able to schedule something with him to be able to talk to him. He will certainly be here with you as well on those dates and times that I just listed, okay? All right. Any questions?
When my attorney.
You have questions for your attorney? You got a Brent Wiseman card?
Yes, ma'am.
Okay, great.
That's his last name. I don't know if we have anything.
You use make a copy. Yeah.
All right, any other questions for her? You're good? Okay. That's his copy of the discovery.
Yes,
Okay.
yes, he's got everything right there.
Great,
And then he's got the AOI that he's working on.
okay. And we'll have you then switch for Mr. Dalton. You can fill it out back there. He can fill it out back there.
Yeah.
Thanks. Yeah.
He was able to turn this.
Oh, you worked it himself? Okay.
He was able to find out.
Thanks, yes.
Thank you. Let's see that. don't know if you've seen Denise, yeah, I think I told you that we've kind of changed the cameras around, so you don't necessarily see who's here spectator wise. And circuit court, like, never see the jurors and stuff, so we're hoping this is a little better vantage point for people when they're, having it on YouTube without having to see who might be here as a spectator, and so, like I say, and certainly we're having the jury.
Yeah.
So it's a little different than probably last time you were here.
Well, you were working it out when I was here last week.
Okay, Cassidy's the one that.
Yeah, he adjusted it. So I'm working on it, yeah. And because that was when your camera was sometimes
Oh,
upside down.
yes, right. When the power goes out, they go upside down. Why that is kind of weird.
That must be default.
Must be, it seems strange.
Yeah.
Maybe they were installed upside down or something, I don't know. Record? We are on record in the Meigs Common Pleas Court in State versus Dalton, 26 CR 076. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name,
Kevin Bell.
and you wrote down your address, phone number, and email on a separate piece of paper. Was that information accurate? And your attorney is going to identify herself.
Yes, I am Denise Bunce and I'm here on behalf of Mr. Gold.
And for the state,
Yes, Your Honor, Abigail Goku, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
and there would be a victim or victims in his case? Were they notified?
Yes.
Are they present?
No.
Did you anticipate they would be? It's way past this time, so
No.
I hope we haven't had anybody waiting. So my understanding, Mr. Dalton, is that the attorney we appointed for you was Ms. Bunce, but that she found out once the discovery, the information was exchanged from the prosecutor, that she has a conflict of interest with regards to a witness and or a victim. So she's not going to be allowed to continue representing you. You understand that? You have to answer out loud.
Yes, ma'am.
And because of that, we're going to get you a new attorney appointed today and get you on a new schedule with that attorney's schedule, because we had different attorneys tend to come different days during the week. So we're going to have to get you a new attorney. And who will that be?
Britt Wiseman.
It'll be attorney Britt Wiseman, and we'll give you dates when he is here. So that you'll be able to meet with him. We'll also give you his contact information so you can contact him prior to those dates, so that you can be well prepared for those hearings. And since you are incarcerated, it'll be a fairly fast schedule as well.
August 10th at 1:30 for an initial pre-trial.
1:30?
Yeah.
Okay.
Final pre-trial motions hearing August 31st at 1:30. And a jury trial September 22nd.
Those always start at 8. And I think you have a business card there with his contact information. You, like everybody else that came in the paddy wagon today, are at Southeast Regional, correct? So he has that number, but you can reach out and leave messages for him and try to schedule a time when you can meet with him prior to that day. So you're not coming in here without having familiarized yourself with each other and your situation. Do you have any questions? None? Okay. Anything else, Ms. Bunce?
I don't believe so. Thank you, Your Honor.
Anything else from the state?
No, Your Honor, thank you.
All right. I think that concludes for the day. Right.